So again, 3 minutes, and this question we've been asking everyone is, you could talk about why you want this job and why you're the best candidate and not the others.
Okay. Hi, I'm Mike Denton, and I am running for the county attorney's office. My wife and I have lived here in the county now for 40 years. I have a long history of criminal justice reform, both as a lawyer and as a judge. When I was the assistant county attorney, I was the chief of the criminal division and managed or led over half of the office. I opened up a lot of diversion programs while I was there, but also in the evening, I was a volunteer at the Austin Rape Crisis Center, going to the hospital and answering the hotline. So when the Center for Battered Women came to us at the county attorney's office and they asked for help in dealing with cases of violence against women, that was something that I had already been working on, and so I helped set up our very first domestic violence court and have been judge of that now for 20 years, ran for it back then. As was pointed out in an opinion piece in your paper last fall, we now have the lowest homicide rate due to domestic violence of any major urban county here in Texas. With the help of a lot of good people, we have saved lives here with that change in the way we handle domestic violence. While I was a judge at the domestic violence court, I also became aware that we had an extremely large number of veterans languishing in our jail. As a veteran myself, graduate of West Point, I opened up our veterans docket in the evening hours so I could do that. And what we did was help the veterans get the help they needed to deal with batterers intervention. And then we dismissed and expunged the case. Several veterans families have come to us to say that we saved the veteran's life. And I know there have been several articles in the Austin American about the Veterans Court. It worked so well, we had the lowest recidivism rate of any treatment court here in Travis County. We thought we would expand it a little bit. So we did the same thing with an offense where we saw repeated arrest without much change, and that's prostitution. So we opened up the Phoenix court where we did the same thing. We gave them the help for the underlying issue that caused them to be arrested, whether it be mental health, drugs and alcohol, and then did the same thing, dismissed the case. Several of the graduates have told us that going through that program saved their life. Again, we changed the way we did it, and we saved lives. I also have already, as a prosecutor, tried cases on environmental pollution. As a judge, I've heard those cases, and I plan to open up a standalone environmental protection division within the county attorney's office. And I'm watching the clock over there. And in the last few seconds, I certainly am going to stand up to the state as they continue to meddle in our local affairs. The way we've tried to stop it hasn't been very successful, so we need to do that better. Thank you.
Good afternoon, everyone. My name is Laurie Eiserloh. I'm running to be your Travis County attorney. I currently work in the Travis County Attorney's Office. I'm the leader over the labor and employment team. Even though I am a management side attorney, I have been endorsed, and the biggest funder of my campaign right now is the union, AFSCME, American Federation of State, County, and Municipal Employees. I think that you can see because of that I'm fair. I'm able to see both sides, and I will be a very fair county attorney and able to, it'll be really actually helpful, I think, for the people of Travis County to have a labor lawyer who's over the Travis County Attorney's Office. You all, I'm a highly skilled attorney and a lifelong reformer. I understand the progress that the office has made on things like Hamilton Pool, on issues like domestic partnership benefits, on issues like LGBTQ rights, environment, abortion rights. And I understand what we need to do in order to bring Travis County into the new era. We have got to have criminal justice reform, particularly as it pertains to people with mental illness. And also other marginalized communities. We must face climate change and try to recoup some of Travis County's losses because of these major rain events. We've got to end that backlog in the family violence court. It can no longer be that justice delayed is justice denied. The county attorney's office is a staff of about 237 people and a $23 million budget. I have the, and we also, keep in mind, we are two sides. We are criminal and we are civil. We are criminal, misdemeanor, and we are civil. You all, I have the experience to lead that office. I've got 27 years of first-year jury trial experience, or jury trial experience. I have a double board certification, labor and employment law, and personal injury trial law, which means I've done tried a bunch of cases in state and federal court. I've taken 2 really hard exams, and I've kept up with my extremely high requirements for CLE in not one but 2 areas. I've worked at the AG's office, also at the city attorney's office. In the private sector, I was mentored by Myra McDaniel, the first African-American Secretary of State. I've tried environmental cases, personal injury, civil rights, all kinds of cases in state and federal court all over this state. What distinguishes me, and I've also was the director of the Lesbian and Gay Rights Lobby of Texas many years ago. So I know what it's like to be a marginalized group that is greatly benefited by policy changes. So you all, I think unlike my opponents, what you'll find, I've got terrific opponents here, highly respected. I've got more experience than, a lot more experience, like many years, more years experience than one of the other front runners in this race. And one of my opponents who is a honored judge, I also have a broader level of experience. So for those reasons, I'm the most qualified person, vision and experience, and I'll be a steady hand in the office. Thank you.
Hi. I'm Delia Garza. I am currently the Mayor Pro Tem and the City Council member that represents District 2, the first Latina to serve in either one of those positions. Would also be the first Latina to be elected to the County Attorney's Office if I am able to do that. The reason I'm running is because our current system works fine if you have access to wealth or privilege. Our current system is full of racial disparities in our policing, in our convictions, and in our jails, and that has to change. What I have learned in my own personal public policy experience, what we've all learned through history, is that you're not going to change outcomes unless you drastically change the system. And I have experience in doing that through extensive public policy experience. One example I will give is the change to the 10-1 Council. I was a leader in that effort. And I would say that because we changed the system of governance here in Austin, Texas, we have the most diverse, the youngest, and a female majority city council. And it took a change to the system to get those kinds of outcomes. And I believe we are one of the most progressive city councils that the city has ever had. I think we have a great system here in that there's felonies under one office and misdemeanors under the other. And I think it's an opportunity for us to fully embrace the diversion programs that have been started, but really gain a lot of traction and really just embrace this idea of diverting people outside of the criminal justice system. I've seen firsthand of the community that I represent, 70% Latino, about 8% African American, that what happens to people and how their lives are affected when they are tangled in the criminal justice system. With regards to why I believe I am the better suited candidate, this is not a contest of who is the best litigator. This is not a contest of who advocates for the best positions but has no experience actually implementing those positions. And this is not a contest of who's been in the system the longest. In fact, it can't be a contest of that because there needs to be change. I think that my experience working on a $4 billion budget, a $23 million budget, I think is, while not to diminish the importance of this office, it is less than our, I believe, Parks and Rec budget. I was able to significantly increase our public health budget by over $5 million that has gone to programs like teen pregnancy prevention, after school care, and things that really help minorities in our community. I think this is a contest of who will best be able to affect real change. And not only have I been boots on the ground, working in the community, crafting, writing policy, implementing policy, and seeing amazing results, like less people in our jail because they can't pay fines in our municipal court, and a better system to appoint our municipal judges so it's not just a political process. And so I'm excited about this opportunity. I think we can really transform this office into one we could be proud of.
Hello everyone, my name is Dominic Selvera. I am a criminal defense attorney. I practice all around Central Texas in Williamson County, Travis County, Hayes County, And I also take federal court appointments where I've handled complex drug conspiracy cases. And I am running for Travis County Attorney because in my work as a defense attorney, I see what's wrong with the system my clients go through each and every time. And so what I've been able to do is fight these battles individually. But what is apparent is that the real change can come from the prosecutor's office because they dictate what offenses are prosecuted. They dictate the philosophy of the office and what they want those outcomes to look like. It's been no secret that for decades we have fought economic injustice and racial injustice across the country and here in Texas. And there's no other place where those two issues meet than in our criminal justice system. Here in Travis County, we have a system that disproportionately affects African Americans, where they make up about 8% of the population and about 24 to 25% of the population in Travis County Jail. We know that if you are arrested for possession of marijuana in Travis County, if you're African American, you're 6.5 times more likely to be arrested. We have clear racial issues in APD that need to be addressed. And so I'm running because we need someone who's got that perspective as a defense attorney, someone who has fought these battles, who is not afraid to say that Chief Manley needs to be fired, who's not afraid to hold law enforcement accountable when they lie, when they perjure themselves. I'm someone who is absolutely willing to do that, to stand up for what's right. There's a national movement where public defenders and defense attorneys are being elected across the country. And that's because we've been in these battles on a daily basis as defense attorneys. And so I've been proud of the work I've been able to do as a defense attorney. And I decided to run for county attorney because I believe that I can make a huge difference in changing the focus of the office to one that doesn't concentrate on convictions or jail time, and one that offers treatment, solutions, and accountability without saddling people with convictions. So I really appreciate this opportunity, and I'm looking forward to answering y'all's questions.
Thank you. So we'll start with you and go the other direction. Give a specific example of a diversion program that is not working as it should be, or a program that needs to be created for a certain type of offense, and how would you make that change happen?
So right off the bat, any drug diversion program I think needs to be handled outside of the criminal justice system. We've been doing the same thing over and over again, where we've been treating substance abuse issues as a criminal justice issue as opposed to a public health issue. And I know there have been plenty of people who have run for DA who have said that over and over, but what do we see at the DA level and the county attorney level? These people are still prosecuted through the criminal justice system, and their treatment is not made a priority. I've been very public that I'd like to see us transform to a model based after what is going on in Portugal, where they have decriminalized every single drug. They had one of the worst drug problems in Europe in the late 1990s. So in 2001, what they did, they actually decriminalized every narcotic. Law enforcement was still able to seize those drugs, but instead of grinding people with substance abuse treatments through the criminal justice system, they offered them treatment outside of that process through the CJ system. And so what it actually did for Portugal, they decreased overdose deaths by 80%. They decreased HIV cases by 50%, and harmful drug use was decreased across the board. So this is a system in Portugal that has the data, over a decade's worth of data, to back up that this is the right model that we should do. But what it would take is for people to kind of change their way of thinking that someone who's in possession of drugs deserves to go through the criminal justice system, as opposed to actually treating them for the disease that it is. I mean, we wouldn't treat someone with lung cancer through the criminal justice system or alcoholism through the criminal justice system. So why we put people who have drug addiction through the criminal justice system, it just doesn't make sense to me. But we've been doing it for so long. A lot of people are resistant to change. But the data is available. This model works, and it's going to take a real leader to say, this is what we need to do. This works. It may be vastly different from what people are used to, but it's all about saving lives. We had about 1,398 overdose deaths from 2006 to 2016, and if you can imagine decreasing that by 80%, what that would do to the families who've been affected by drug use, I just think it's time that we rethink the way that we handle drug use and drug possession in Travis County.
I think that our diversion programs do not often get to the root cause of the problem that created the action that resulted in a crime. DWIs, when the root cause could be a mental health issue, and instead we require them to be monitored, and you're not allowed to drink, and you're not allowed to do all these things, and these very strict rules to get somebody to be able to agree to a lesser charge. I think that's a problem. I think that's why I think the beauty of this system, this two-tier system of misdemeanors, allows us to address some of these offenses in a different way, in a more social worker type of way. And the other part of these programs is you're required to pay for that. So you're required to pay for your monitoring. You're required to pay for classes. Some people will not be able to participate in diversion programs, period, because they can't afford to pay for those programs. And obviously those affects, as I mentioned before, the system works fine if you can pay for those kinds of programs. If you can plead for that lesser offense to pay for programs. But if you can't afford to pay for those programs, you can't participate in them. I think the experience that I have in working on budgets, it's all a matter of allocating resources and making sure we're allocating them in the right way, in a more human-centered way. And I think that that's ways that we can change our diversion programs, as well as when you have offenses by somebody, there needs to be a more holistic approach. So when you have offenses by somebody, for example, who has been sex trafficked, and the trauma that that person is dealing with because of being sex trafficked, and they have created some offense that you wouldn't naturally maybe connect to that, but we have to recognize that there is trauma related to being sex trafficked. And I think Safe Alliance is doing a good job of providing housing and programs and temporary opportunities for people in that instance. But when I have talked to Safe Alliance, in fact, they have said there is not that better connection between finding out what the root cause is. Why is this person in the system? I think the city of Austin, the downtown community court, does an amazing job with diversion programs. They do things like finding out that somebody something as small doesn't have an ID. And because they don't have an ID, they can't get a job or get housing. And they tell them, okay, your diversion program is to go get an ID and come back. And they come back and usually their cases are dismissed. And so I think we can be more creative and more compassionate and with these programs, and more aware of the issue that we are not facing a misdemeanor criminal crisis. We are facing a mental health and a public health crisis, and we have to address that differently.
Well, I'm glad you asked the question, because in Travis County, we have 27,000 open misdemeanors. That's a lot. And every single one of those puts a shadow on someone's record. It makes them not eligible for employment. It can affect their immigration status, their student loan status. It can keep them from getting certain job certifications. I think in Travis County, we've got to get real about our lack of mental health diversion. I visited Harris County last week and toured their mental health diversion facility. And while it's not perfect, it is something that I think we need to look at carefully in Travis County. You walk into their booking facility, and on the wall is written intake, and on the other wall is written diversion. And I bought some pictures for y'all to look at. But The police officers can divert from the field, or they can divert from the booking center. And from there, the mental health diversion, they actually have a records computer where they can see what mental health records you have. And they can divert you either to the mental health diversion center, which is kind of a mid to low level, or to a psychiatric hospital. But you don't have to go to a jail. And what does that save you? Well, they said, for example, there was one gentleman in there who had so many theft of minor food items that he was just about to be moved up to a felony charge. Instead, they diverted him into the mental health program. Is this a perfect solution? No, because they have trouble with recidivism, and we will too. But it's something we need to look at. And I've been talking with Judge Guy Herman and some of the other judges in town about how we might do that here. So that's mental health diversion. Right now, we've got no place to divert them to. People with mental illness are going to the jail. They're good nurses in the jail. But people with an illness, they don't need to be jailed. They need to be treated. And that's one thing we need to look at. The other areas that I'm quite concerned about, over in Project Engage, which is the court for young people, that's Randy Mueller's court. Since we don't do a lot of intake in Travis County, we need to start doing that so that we can identify up front who is eligible for these programs and mark them for that. Because right now, if a young person is out there, a 17, 18, 19-year-old, they may never find their way to Project Engage. And that's a real shame because that's meant to help them, right? The other thing I'd like to see us do regarding Project Engage is right now we're relying on officers in the school, these school resource officers, again, good public servants. But we need to start looking at using restorative justice in the schools rather than having those kids, 17-year-olds, come into the criminal justice system. We've got to do something better there. A couple of other areas that have come up right now in the Veterans Court. If you have a family violence a matter pending, that may prevent you from getting in the Veterans Court. But of course, PTSD is one of the reasons why you may have a family violence situation. So we need to streamline that process a little bit. I have some other ideas as well. I'm going to stop. Thank you.
One, I don't think we should limit our diversion programs to a particular offense. It's across the board. The county attorney is lucky in that what we deal with on the criminal side are misdemeanors. And whether it's shoplifting to assault, if we can change the underlying behavior, then that's what diversion is about. And that's what I've done over the last 20 years with the various courts that I have run and prior when I was a prosecutor. As an example, the veterans or the prostitution court, where we give them the help that they need to deal with whatever the issue is that caused them to be arrested, change the behavior without a conviction. The law is very clear. It says prosecutors' job is not to seek convictions, but to seek justice, and that's it. As the county attorney, what I have already said many, many times is we will have a very aggressive deferral program across the board. And, it could be shoplifting, and it may be that the underlying issue is I'm 17, and I need a second chance. Which one of us in this room didn't do something when we were 17 or 18 and we didn't need a second chance and we're lucky we got it? Or it can be TBI, traumatic brain injury, that results in an assault on a family member as they deal with the frustrations of having TBI. Across the board. And so we need to have and will have at the intake division. Right now the intake division has very junior people in it filing cases. One of the many changes I've already said that I will make is we will put senior experienced prosecutors in the intake so that they can review cases and divert those that look like they are prime examples for diversion programs. And so we will get them into it. As I said, I have a 20-year as a judge history of establishing diversion programs out of whole cloth, getting everybody to the table to agree. As an example, when I set up the Veterans Court, I was contemplating dismissing hundreds of cases. I had to get the police on board before I did that, and they are on board. You have to bring everybody together when you make these, and I have done that over the years. When we first talked about combining the district and county attorney's office here recently, one of the major objections to it was misdemeanors get this treatment, and they were afraid that felony prosecutors would not give emphasis to the misdemeanors and the deferral programs. County attorney is in the unique position to stop people on that bad path when they get one arrest that will lead to another arrest and a bad life. When I was a prosecutor, I had 17 and 18-year-olds shoplift and come to court, would have been an easy conviction. Instead, I put them on deferral. That was, 30 years ago, so they're now about 50 years old, and I like to think by giving them deferred a second chance, that there are some people out there now that are 50 years old that have a good life, good family, all because I took the step of putting them on deferred and not going for a conviction. And that's what we need to keep doing in the county attorney's office.
Start with you.
Yes, sir.
You oversaw the domestic violence court.
Yes, sir.
There's been complaints, concerns about the backlog of cases at that court. I think some cases, a backlog is 2 years or some. Cases left pending for more than 2 years. So what are the main factors creating that backlog? And what would you do as county attorney to erase it?
Sure, and thank you, because a lot of the numbers never get mentioned. They just make the statement backlog. In 2018, there were 800 more cases filed, criminal cases filed in the domestic violence court than filed in any other misdemeanor court. Also, there were 500 to 600 protective orders filed in the domestic violence court that, of course, are not filed in other courts because only the domestic violence court hears those. So that's well over 1,000 more cases were filed in the domestic violence court than were filed in any other misdemeanor court. And then look at the kind of cases they are. Do you think in DWI cases a witness receives a phone call that says, if you testify next week, I'll fight you for custody? And the truth is, that's one of the nicer threats that I've listened to over the years. Routinely, victims have a hard time to come forward and testify. I was told there was a jury trial just this Monday that over the weekend the victim called the state and said, even though I told you I'm going to testify, I'm not going to testify. It takes longer for those cases to be prepared, and they have to have witness coordinators, is what they're called in the county attorney's office, talk to them to get them to come to court. So you have more cases and they're harder to bring to court. And in fact, the idea of more victim witness folks talking to them, in February of last year, there were roughly 600 cases on the jury docket. In September of last year, there were 300 and something cases, almost a 50% cut. And the only change between February and September was the county attorney put more lawyers and more victim witness coordinators in support of Court 4. So they increased the amount of support for that court and halved the backlog. The county attorney is the one who controls that. The other thing the county attorney needs to do, and we will do, is screen the cases coming in. As I said, very junior lawyers are now in intake. The county attorney has its own intake division, as I understand it now. The cases need to be screened rigorously when they come in, not as the case gets set on a trial docket, but in that first week, we need all the evidence. The county attorney must interview the complaining witness, and then they need to sit down and decide, is this the kind of case we should file or not? And then once filed, that means less cases will be filed. And then in court, as we saw last year, by increasing the number of victim witness coordinators and lawyers, that will reduce the trial load as well. So the cases that are filed are the ones the state plans to go forward on, and they're not going to file cases that then end up being dismissed at jury docket, which routinely happens, unfortunately, right now. I was told the last 3 weeks there hadn't been a trial go forward on Monday, which is the normal trial day. It's beyond ken that you wouldn't go all the way to the day of trial and to dismiss the case because the evidence wasn't reviewed as rigorously as it should have right up front. So more assets to the prosecutors in screening them coming in, and we've seen that by the numbers. That makes a difference. Plus the cases are different, and there's so much more of them being filed.
Okay. So the way I understand it, or how I've kind of organized this in my mind on the criminal side, is that there's basically kind of 3 batches of cases. There's family violence, DWI, and everything else. Now, that's a little bit of a broad brush, but that's how we're looking at it. So this is a large piece of what the county attorney's office does. The thing about the family violence court is it was heavily backlogged. When Judge Malhotra took over, I believe there were, I want to say 400 pending cases, a 2-year backlog, and some of that really was that the cases weren't getting to trial very quickly. The problem with this, you all, is that justice delayed is justice denied. It's causing women or people who've been hurt by batterers to not be able to get their day in court. Memories fade. Unfortunately, there is some pressure that's put on victims to drop the charges, to not testify. So this backlog, it must end. And here are some ideas that I've had, and I think that actually some of these may have already been adopted because we were talking about them back a few months ago. One thing I'd like to see us do is better intake. Now, this is something I've been talking about for a while, and we do need an experienced prosecutor between the police and the jail, not only for this, but for the other areas we work with as well. And I think one thing that will do, it will make it possible for at least identify, and I know this is a little bit shaky ground, but are there some cases that would be eligible for for diversion here? Maybe there would be. Are there some cases that would be eligible for restorative justice practices? Maybe so. I think what we are looking at, though, basically, is we're going to have to open up another court that will be handling non-intimate partner cases. I know that's something they're already looking at. I feel very strongly that this court be a court that's trained in family violence. I've talked to at least one of the other judges. She is willing to take on those cases. But I don't know that we can continue on with Court 4 as the only family violence court. These are courts of general jurisdiction. Any of them could take these cases and in the backlog. The problem is you lose the specialized training that Court 4 has, and we've got to have that. The other thing that we need is, quite frankly, a change in the culture over at Court 4, not only from the judge's perspective, but also from the prosecutors. If you've got a case coming up, it can no longer be that you've got a special connection, that you're going to, say you aren't ready today. If you've got a trial setting, we got to hold your feet to the fire and make you go to trial. And I'll tell you, the first few times that happens, it's not going to be pleasant. But that's the type of thing we need. I think another specialized court using those same Court 4 prosecutors, not opening up a whole other team of prosecutors, just another court. And then I think we need to hold people's feet to the fire. And I think we need to do a better job on screening the cases. Okay, thank you.
We've been talking about this issue on this campaign trail, so I think we have all very similar solutions. But back to the allocation of resources and why it's so important. And I think for so long, crimes that significantly affect women more have not been prioritized. They have not gotten the resources that they deserve. When backlogs don't come out of anywhere. There has got to be a trend that somebody has to recognize to see a backlog is building up. And it is then that we have to do all these things. Give those other judges the proper type of training that allows them to preside better over these kinds of cases, and then move some of those cases to other courts to address that backlog. The taking out the non-intimate partner, I believe, is something that has happened because the non-intimate partner is a different dynamic. It's not the same power dynamic that you see in a traditional domestic violence case. And I believe that has happened and that has reduced the backlog. It's my understanding that the backlog has been reduced significantly under that new judge. I'm starting to have to do this. And I think that, again, victims deserve their day in court. And the stories that I heard were cases being reset and reset and reset. And when cases continuously are reset, in the interim, for example, if the end result was anger management classes or some kind of diversion program or some kind of social program provided to the abuser, that just didn't happen during those resets. So you have this time span of when the actual incident happened to when it would finally be decided what the plan was, so to speak. And we lost so much time in between there for the types of programs. But what the county attorney can do is the better screening and allocating resources where needed. This happens all the time, and at the city council level, when you recognize something needs attention, and you get people from other departments to come and help out. That in that area. The big thing right now is our code rewrite, and we have people from our transportation department helping, and that's what you have to do when you are over a big system. Is you recognize where there are backlogs, where there are deficiencies, and you as quickly as possible, divert the necessary resources to address those, especially now in this time where we are, I believe, as a culture, as a community, as a country, recognizing that violence on women has not been recognized the way that it should be, and so people deserve their day in court, and defendants deserve their day in court too.
So I will say that this is part of a more systemic issue that you see in the county attorney's office and in DA offices across the state. When there's an identified issue, how do you fix it? Do you take little baby steps to address it by adding another domestic violence court, or do you make wholesale changes to actually address the issue? For me, I would like to see all of the domestic violence cases spread out through every county court in Travis County, because we have county court judges that are all qualified to handle these cases. We have county attorneys who are all qualified to handle these cases. So the fact that we funnel them into one court and we see this backlog and it just continues and continues until it's election time, and then all of a sudden it's a problem, and now let's address it. So forgetting the people who have gone through these issues, victims and defendants who have had to wait years for justice. Finally, when it's election time, you kind of see possibly some relief at the end of the tunnel. So for me, I think there are two solutions to fix this backlog. One, distribute those cases throughout the county court system, provide training for attorneys handling those cases, and also, like Laurie mentioned earlier, I've been talking about this for a long time. We have to have a restorative justice option in Travis County. But what that means is we need buy-in from community groups who provide those services. We need funding from the commissioner's courts. And that's a whole nother bag of worms to where, really, in my opinion, we have the money, but what matters is where does the commissioner's court see fit to make those types of social investments. We went through this when we fought to bring a public defender's office. The biggest battle was, how were we going to pay for it? And so if things like this are a priority to you, handling domestic violence cases in Travis County, we have to invest the money. We see when it comes time to give yourself a raise from the commissioner's court, no problems there. But when it comes time to invest in these types of programs, you get pushback. And I think that has to change. We have to invest in handling these cases with the special care that they need, and that means having these cases spread throughout the county courts.
May I respond for a few seconds to some of that?
How about a minute?
Okay, less than a minute then. Several things were mentioned. One, resets. In the old days, before Court 4 was set up, when everybody heard the cases, once the victim was intimidated and didn't come to court, the case was dismissed. Docket moved very fast. There weren't any resets. Women died. Back then, you have, I know that you have access to the numbers. We had an annual homicide rate of someplace around 10 to 14, depending on what year it was, according to the Austin Police Department. Safety drives the decisions in that court. Here's a study the Texas Council on Family Violence did a year ago, and you can see the average of the homicide rates of all the major counties in Texas, and you can see of all the ones with 1 million or more population, we have 3. 3 is way too many, but we had 3. Fort Worth, who were always compared to, I believe they have 10 or 12 on there, and Dallas had the other number. Houston is up around 30, and it's actually jumped to 40-something, I was told, this year. Safety is the decision. Spreading them out resulted in fatalities. I'm sorry, I used your minute.
No, that's okay. All right, that was an arbitrary number.
Well, and I would say safety is the decision. Yes, I have also moved some cases out when it was a non-intimate partner, but everybody in this room knows the week after Christmas, a young man here in Austin stabbed his pregnant sister to death. The same week, south of here, a young man stabbed his grandparents. When you live in the same house, safety concerns are different, danger is different. And so the decisions made back when it was spread out, we had high fatality rates. By doing it this way and making decisions and understanding the different dynamics in a domestic violence relationship, we made it safer, as those numbers reflect. In a standard relationship, I might send you a letter that says, I love you. What's that mean? It probably means I love you. In a domestic violence relationship where a judge has said there's a protective order issued, you are to have no contact, and I send you a letter that says I love you, do you think the message is I love you? Or is the message, I don't care what that judge said, I can still get to you? You have to understand the dynamics of a domestic violence intimate partner relationship to understand what's going on, because what doesn't make sense in another situation, a non-violent intimate partner, if you understand intimate partners, am I a criminal trespass? I'm just looking to get out of the rain, or am I a criminal trespass because I'm hiding around your house, stalking your daughter? Each case has to be looked at, and safety has to drive those decisions. And that's why, as county attorney, I will, as was done the 6 months prior to me leaving, put more assets in there. And we will also screen all cases right up front hard to decide which to go forward on. But safety is the deciding issue. Simply doing it the old way, dismissing it when the victim didn't show up, we had very fast dockets. We also had fatal dockets. And that's what we were trying to change.
So I think it's misleading to correlate safety to a specific court. If you've got the same program replicated from court to court, where a person's case resides, they're not thinking about that if some sort of bad outcome happens. They're not thinking, well, I'm in court 4 or I'm in court 3. I'm not going to commit this offense. I'm not going to recidivate. If we've got the programs replicated in each court, safety is going to be the number one concern. So to relate additional violence to what court a case is in, I just don't see the correlation.
Anyone else need more time on this one?
I mean, I agree that it's spreading the cases out, and I think we've all said that. I think it's also a matter of there is specialty training that comes with these kinds of cases, that if we are going to spread them out, we need to make sure that the prosecutors are properly trained in this type of trauma and incident, and that all the judges are properly trained as well.
These are team cases, right? There's a court and there's a prosecutor, and there's also the staff that goes with it. So the prosecution team is around court 4, right? So it's not just as a matter of training another judge, right? And we're going to have to be able to get the prosecutor and the team to that other court, or train more. But as I mentioned, as I started this with, we've got 3 batches here: DWI, family violence, and everything else. So we're going to have to do this efficiently. I just personally think an efficient way to do it is to identify another court that has the same training, and it would be the overflow for court 4. That's all I'm saying. I totally agree with Judge Denton. I mean, safety's got to be the number one consideration, and this training is important for the prosecutors, the court, and everyone around that, the social workers, the staff. It's not just a matter of, well, yeah, we got court. They're all courts of general jurisdiction. Sure, they are. But this is a very specialized area that we're working in. But it cannot eat up every single resource in the office. We got to figure out a way to let it go forward efficiently. Okay?
Under the category of everything else that you just talked about,
Mm-hmm.
there's trespassing, which you mentioned. There's prostitution. There's low-level pot. Should the county attorney's office continue prosecuting those kinds of cases, those low-level cases, or should there be some other remedy or some other way to tackle that?
So,
and we can just do 2 minutes on this, and we'll start with you.
okay. So in terms of those low-level cases, what I would like to do, now keep in mind the county attorney's office was the one that stopped prosecuting on marijuana, possession of marijuana, right? And so I would like to continue that policy. But further than that, I'd like to expand that policy. That was all done with a pre-booking diversion program through Judge Nicholas Chu, okay? And our office worked on it, and Judge Chu worked on it. I'd like to see that program of pre-booking diversion expanded for other low-level drug possession crimes, for people who don't have a terrible record, that criminal trespass, theft of food items, things of that nature. And that's really what they did in Harris County. I'd like to see us divert those cases. And when I'm saying pre-booking diversion, that means you are not booked, fingerprinted and booked into the jail. Why are we going to do it like that? Because we see an opportunity to rehabilitate you. And we also see an opportunity for you not to have that on your record. And just as an employment law attorney, I just can't tell you the pain I've seen from people who can't get jobs because they've got this stuff on their record. Either they were desperate, or they were stupid, or they had a minor addiction going, or any number of things. But we are saddling them with a lot when we do that. So I'd like to see the pre-booking diversion expanded. And of course, in Harris County, they're doing it with mental illness too. And that's what I'd really like to see us try and do. Now, that's a very tricky area, you all, because there's nothing to, without the force of law, there's nothing to keep that person in that diversion center, right? But we've got to figure that out. And I know there's apparently, I was talking to someone in the jail lately, and there's a program in the Bronx we might be looking at. But these are all pre-booking diversion programs, and I think we need to do more with it. But the basis of it, what we were doing in Travis, was pre-booking diversion on pot. Well, now that's all kind of, that's good. We just need to do more. And I'm open to doing more. Shoplifting, just anything we can do to give you a second chance. That's the beauty of the misdemeanor prosecutor. And I want to get that going as soon as I'm in office. Thank you.
I do not think we should be prosecuting non-violent offenses like the ones that you have explained. I think this goes back to my opening comments about getting to the root cause of some of these activities, why people are engaging in prostitution or low-level drug possession or criminal trespass. There is a difference. I think as Judge Denton pointed out about criminal trespass, because you have nowhere else to sleep that night and you're looking for the safest place, and it happens to be on private property, so that's where you go to seek shelter that night, versus somebody who is, stalking an intimate partner. There's obvious difference there. That's the beauty of the law, is that you get to analyze each case by case and understand the facts of it and address it depending on those facts. As a council member, I'm proud of the work that our council has done in reforming some of these efforts. Most recently, passing a policy that that we would not arrest or cite people for low-level marijuana, which to many of ours extreme disappointment, our chief has defied that, when I do believe it is the city council's purview to dictate policy on how we share, what we do with our resources. And it is pointless and makes no sense to be handing someone essentially a meaningless piece of paper that will not result in punishment, because these cases are not being prosecuted and will likely not be prosecuted. I can't imagine any of us here all of a sudden going after this 2-year statute of limitations on anybody who has been cited for low-level marijuana. There has been no proof of crime going up in areas that have, in jurisdictions that have either legalized it, medical marijuana or personal possession marijuana. I believe there was one case where, can I just finish the thought, where there was an instance of crime going up in those jurisdictions, but there was a nationwide crime spike. So, causation and correlation do not equate. And so I think it's a waste of resources to be prosecuting low-level nonviolent offenses.
So, without question, I believe that we should not be prosecuting marijuana cases or any misdemeanor possession drug case that comes through the county attorney's office. And so I'm talking about that you don't have to take a class, that you don't have to pay a fee. For me, it's laughable that someone who is in possession of a joint would need any type of diversion program. That just, there's no basis in reality for that. So while we're using resources for those types of cases, you've got the family violence backlog where you could be diverting more resources. We have to get to the underlying issue, like Councilwoman Garza said. That's how you actually improve safety in our community, when you invest resources at the city and the county level into mental health treatment, into substance abuse treatment, and you do it without the threat of incarceration, without the threat of a conviction, if you really want to help people, that should be the solution. You offer people services, and if they relapse, if they hiccup, they're not looking at getting revoked. They're not looking at getting drugged back into court to take care of a criminal mischief case or a trespassing case where poverty is the underlying issue. So for us, it's really about the attitude that we have towards these types of cases. Are we really interested in getting to the root cause and actually helping people? If we are, we would invest our money in those services. And for me, that hasn't been done enough. We certainly have a long way to go. When you talk of, well, I'm out of time. I was about to talk about the money we waste on bail, but hopefully that question will come up.
We need to have a question about the civil side too. We've been all in the criminal. Maybe I'll have a few questions about that. I just noticed the time.
Actually, I want to give you a chance on that last question.
On diversion? Okay.
For the low-level crimes that we're
Okay,
talking about.
without a doubt. I obviously have a record of setting up diversion programs. I've mentioned the veterans in the Phoenix or prostitution diversion courts that I did in the evening hours when I wasn't doing my other job. I obviously believe in diversion programs. At the county attorney's office, I think any offense, you said just the low levels, but any offense where safety is not an issue or somebody's not taking somebody else's rights away, like hate crimes or the criminal trespass when they tried to block access to women's clinics here in town, when Operation Rescue did that and I prosecuted them. But in the cases where somebody's not taking someone else's freedoms or is not a safety issue, I think diversion is without a doubt the right way to go. As I said earlier, if we can change the bad behavior, whether by counseling, like with a veteran who needs to deal with PTSD, or the substance abuse of the young woman who was arrested for prostitution last night, if we can, or the shoplifters I mentioned, if we can change the bad behavior, then that's what it's all about. Because that is justice, because we've given them that second chance at life without a record that will have all those horrible effects on your future job, home. Almost everything that we do, having a criminal record will affect it. And so this is the pipeline to the pen that everybody talks about. And in the county attorney's office with misdemeanors, we have the ultimate way to get them off of that path. Change the bad behavior and let them have a second chance. Now, if they are a danger to someone else, or like Operation Rescue, they're taking away someone's rights, that's a different matter. But if safety is not an issue, I think deferred disposition, if we can do it up front, that's great. I think we should divert people to sobering centers. I think we should divert people to mental health facilities where we can. Unfortunately, we don't have all the centers that we need for that, but we certainly need that. So diversion for essentially across the board unless safety is an issue.
Or we need more time.
We're at 2:56.
No question? Do you have one that you want to ask?
Yeah, I think you've got more important ones there, though. So,
Do you?
but if you can give a minute, I'll ask about something that's near and dear to our hearts, which are Open Meetings Act violations. You don't see it very often, but I think there's a way for the county attorney to get involved in Information Act disputes. So, I guess my general question is, how important is that to you, and what would you do to keep our elected bodies accountable to those transparency acts?
Start with me? Sure. Whoever.
I'll start with you. Go ahead.
Sure. I have two parts of that question. One is a transparency. And without a doubt, we have to be transparent. One of the things I have promised, as an example, I talked to a lot of people about criminal justice reform. And when I was told by a reporter that if you ask for numbers on the arrest, race, that sort of thing, you'd enter into a fog because it's hard to get those kind of numbers. I will keep those numbers about what comes into the county attorney's office and release them. I know there was a big fight recently about deferred prosecution agreement made available for people to see. As far as I'm concerned, everything that we do in the county attorney's office is open, and it will be open, and I certainly will be advising the commissioner's court that we need to do that. Open records, I think that's been one of his priorities, I know. For years, David and I have talked about that. He and I are friends, And I agree, we have to make sure that open records rules are followed. I, over the years, have sat in the grand jury with Ken Oden back when I worked there, when this issue came up. Excuse me, we certainly need to enforce that. I'm not sure exactly what you're asking me, but you said 1 minute.
I didn't have a very specific.
Yeah, it was.
but yeah.
So I might loop back around then after everybody else takes a shot at it and I see where we're going.
So you bring up a really good point. The county attorney's office has prosecutorial authority over open government violations and has exercised that authority regarding the city council. And recently, I think it was the school board, there was an issue that was brought up. It looks like they were able to kind of work out something along those lines. But let's be really honest here. This is a very special role of the county attorney's office to be able to prosecute for open government violations by other elected officials. And particularly here in Austin, Travis County, y'all, there is a lot of money on the table in front of these governmental bodies right now. And there's a lot of pressure on everyone to, to get their deal, basically. And unfortunately, the government, if you, in that type of atmosphere, the people can be left out. So, for instance, I believe the problem with the city council several years ago was a roaming quorum. Well, the problem is if you're having a roaming quorum, when can we, members of the public, hear what you're talking about, hear your debate? You've not posted it. We can't get in front of you and listen to it. And that's a big problem. So, we haven't talked about the civil side of our office, but that's where I work. Yeah, there's millions of dollars. We are advising 50-plus elected officials. And just to tell this, just to say this, when those elected officials pick up the phone and talk, they need to talk to a lawyer. They're not calling you to talk to the politician. They're there to talk to a lawyer. They need help on these things. So on the civil side, we are very cognizant of at least Travis County's open meeting issues. We help look at the agenda. We make sure that everyone stays on point. But that's not our only, that's just Travis County. We're talking, our enforcement authority goes countywide to other elected officials, and even broader than that, arguably. So this is something that I take very seriously as someone who's lived in Austin a long time, but also as an assistant county attorney and someone who's had to make sure that we're on track. And one of the things that one of the commissioners told me, she said, you know what, if you get this job, you've got to keep us on track. And I said, yes, ma'am, I will. Okay.
I'll just start with saying we're all lawyers here. And I think of those of us sitting here, I know firsthand the Open Meetings Act and why it's important. And when I came on city council, it was right after the previous council was the one that was facing possible criminal issues because of a walking quorum at that time. And because of that, many of us have taken an incredibly conservative view of what that meant, and tracking every council office we talk to, and not even if it's just our office, if it's if my chief of staff talks to another, that counts in the office. It's incredibly important. It is about transparency. I think that is why one of the reasons why our meetings go so long, because a lot of the public discussion happens on the dais, and it is the public's right to be part of that discussion. It's also because we do take significant public comment, more than many other jurisdictions take. When I go to meet with other city council members through different organizations, and I tell them the length of our meetings, and I tell them the rules that we have, they are amazed that we're just not going through items like that. And it's often because we can only talk to a certain number of people. Our bulletin board is used way more than it was ever used by any other city council, because of concerns about transparency and making sure that the public felt none of this was happening behind closed doors. We can talk to 4 other people. That is our subquorum. That is where you get into the meat of policy, and then you're able to have these discussions in work session. But it is absolutely important to be transparent, especially for our media. I feel like our media has saved us a lot under this current administration of President Trump.
So I will say that public confidence in our elected officials will be a priority if I'm county attorney. I think there's nothing more disheartening than having elected officials commit wrongdoing or even having a sniff of wrongdoing. Accountability and transparency are going to be at the heart of what we do in the county attorney's office. If you look on the county attorney's website right now, can you find any stats on race, outcomes of court cases? I can't find any. So just that in and of itself kind of tells you where we're at in the county attorney's office. And so I've been clear, one of the first hires I'm going to make is a data analyst whose job is to gather that data and put it on our county website so that regular people who don't have involvement with the criminal justice system can look at it, can gauge how we're doing, and really hold our feet to the fire to make sure that the things that we promise, the things that we say that we're going to do, we're actually doing. And not just that, but gauge what our progress is, because the only way we're going to be able to make any improvements is to make that data public without people having to do a public information request or any type of Freedom of Information Act. We've got to be upfront with what we're doing, and we've got to provide the data so people can see it. I think that's important, and I think that's how we hold ourselves accountable, not just other elected officials. But if we can't hold ourselves accountable as a priority, how can we be expected to hold other officials accountable as well? So that's going to be very important to me.
I'll do one last quick one. Just 1 minute on this one, and we'll go this direction. You and one other of you has said that the county should fight back when the state tries to overturn local government policy decisions. Is that the county attorney's place to do that, or does he or she serve at the direction of the commissioner's court on that kind of thing?
So
it's
yeah. I mean, it's our priority to protect local control. And so if Governor Abbott or any state agency wants to dictate to us or bully us into taking a certain position, we're going to fight it. I mean, I think I've made it clear that I'm not afraid to stand up to any bullies or any elected official or person in power when I believe something is wrong. It just, it goes against what I believe in to allow someone to bully me or something that I care about. So we're absolutely going to fight it vigorously, because what we do here in Travis County is important. We are allowed to dictate how we handle local issues, and I'm absolutely going to fight to make sure we continue to do so.
I think to the extent that litigation could be expensive, the county court obviously holds the purse strings to the budget. But that doesn't mean that the county attorney can't be going in front of that county commissioner's court and saying, this is something that we should do, and this is why. For example, the SB4 lawsuit was one of those. It happened the same way at the city level, when council, myself and 4 other council members, I believe, directed our city attorney to file the SB4 lawsuit, which is ongoing. We, I think, have won on a couple of issues, but have not, there's still some pending things, and it's still in the court battle. But I think that's where it is important to have somebody whose values reflect the values of our community, and who's willing to stand up and who's willing to make a statement. It is a lawyer's job, but it is also our job to fight for our community, especially the most vulnerable. And when there is any instance of a state overreach, which continually is happening, and I can imagine in this next legislative session over the homeless policy, there could be another attempt at state overreach. It is incumbent on whoever is in this office to have the political courage and the boldness to stand up and say, we need to fight back against this. And I have a lot of experience doing that. I feel like being the main target of Greg Abbott right now, the council who is the main target of our governor, Greg Abbott, right now.
Okay, I was actually one of the attorneys, a key member of the team who defended Sally Hernandez and also sued Governor Abbott over SB4. And if you recall, Abbott was on the radio and he said that he was going to, quote, hammer Travis County, okay? So the way that worked, the county attorney's office jumped in there, and I was very proud because Fifth Circuit adopted some of my reasoning, actually, in dismissing the lawsuit against Sally Hernandez. But keep in mind, you all, we are the lawyers, and we are, under the Texas Constitution, we are judicial branch. We're not legislative branch. So it's lawyer-driven, but it's client-driven. The lawyers don't jump out in front of the client. The client gives us, they want to cut a path forward, and we're the ones that help them to do that. Now, sure, we've absolutely got to be bold, and we've got to have the creative ideas, and we must have the courage to do it. But we are still, at the end of the day, the lawyers and not the legislators, and such as it is under the Texas Constitution. In fact, we can be removed by the district judges for being incompetent. So that's our role.
It is the commissioners who get to make the decision. They need to have a lawyer, though, who's willing to do it and able to do it, which I am. When, in response to all that before, the governor took away several funding sources from us. Veterans Court, Phoenix Court directly impacted me, but several others in the county. I all but begged various people in the county attorney's office to please push forward with a lawsuit. LA filed this lawsuit on the exact same facts and won in federal court. I wished we had done the same thing, but I couldn't convince the county attorney to go forward with that. We have the ability to do it, and we should do it. Otherwise, he will continue to meddle in our business.
May I respond?
Sure.
And this is because the SB4 lawsuit is very personal, I feel like, to the Hispanic community, because it was incredibly racist and targeted the Hispanic community. Ms. Eiserloh will say that she led the lawsuit, or she was part of that lawsuit. And when I have pressed and said, there's all these great ideas, why weren't those ideas implemented since you've been there so long? All these great ideas. And the response has been, because I was a worker bee. So I feel like you cannot take credit that you were the one that led the SB4 lawsuit or worked on it, but at the same time say, I did it because I was told to do it. This is an elected position. Whether politician carries a negative connotation to it or not, it is a political position. And we need somebody who's not going to step back and say, I'm just advising my client. My job is just to advise my client. In the case of the city, where it is an appointed position, I could see where the city attorney can say that. I am here to advise my client. But when you are stepping up to represent a community, and your values should reflect that community, you need somebody who's willing to do things differently and to not do things the old way.
Well, obviously I get to respond to that. So, you all, I'm over the labor and employment team for Travis County. I've also done a lot of civil rights work, and I'm a damn good litigator. I know that I've practiced in these federal courts in the Fifth Circuit, and I know these courts quite well. I am over the labor and employment team for Travis County. In that area, I've made great changes, right? In other words, we've just adopted a new policy whereby we have even more people who are just cause employees, not at-will employees. But in terms of me getting in front of my boss, David Escamilla, on SB4, that's just not realistic. It's not how our office works. Anyone who knows about how the county attorney's office works is the buck stops with David Escamilla. He is a great boss, he's a smart attorney, and he's always there for us attorneys when we need him to help us resolve a gray area, and he's there for the client. That's our day in, day out work. This office looks like a law office, and because we are, under the Constitution, we're attorneys. And we have those tools, and those are the tools that we fight with. And nobody at this table has more experience in utilizing those tools of litigation, of moving forward through the courts than I do. I mean, that's just, there's no other level of experience. Now, I'm not saying other people don't have good experience in their areas, but this office is a law office, and I'm a lawyer, double board certified, with 27 years of litigation experience.